so we'll go from there. Here with us today is Lindsay Smith from the Department of Revenue. She is going to be going over what we lovingly refer to as the Board of E&R charge. It's kind of her duties and responsibilities. First time I've met Lindsay, she is from Yancey County out on the Tennessee line.
Okay.
And so she drove in, I think, yesterday
Yeah.
to spend the night. I don't know why she didn't want to commute this morning, but
Yeah. I didn't want to come through Charlotte this morning.
I was a little scared to do that. I got rerouted yesterday from a crash, and it took me about 30 minutes out of the way, so I figured that on a Monday morning that might be.
Good move. Good move.
with that, I will turn it over to her, and then we can answer any questions directly from you all. We do have four on Wednesday or three? We have 3 appeals scheduled for Wednesday morning. All of them are late exemption applications, and so we'll hear those Wednesday morning, and that will be all until the next meeting, until probably the 1st of May, give or take. So, Lindsay?
Perfect. So just a few things. If you have questions while I'm in the middle of the presentation, feel free to ask. Some of this stuff is clear as mud. And if you need to take a break in between, I'm hoping that we can kind of get through this pretty quick. But if somebody needs to take a break, just let me know and we can stop for a minute. Okay. Property tax appeals.
Do I have a pen? I've got mine.
There's one there.
Bellamy, you got pens?
No, there's one down there. Go ahead, sorry.
No, you're okay. So I'll just go through kind of what we're going to be doing today. First, we're going to go over property tax appeal process, the powers and duties of the Board of Equalization and Review, hearing preparation, general considerations, appraisal standards, personal property, and then discovery and related statutes. So the appeal process. Who may file an appeal? Anyone who owns or controls property within the county. Joint owners may file separate appeals, their own or the property of others if aggrieved. So if you think your neighbor's property value is too low, you can appeal those. An NC licensed attorney, business entity representatives, so principal officers, member managers of LLCs, full-time employees that are authorized to do so, and then an authorized owner. Sometimes you'll have family members appeal on behalf of their family member if there are medical issues, some nursing home situations, you'll have that. Tax reps, it is recommended that a power of attorney is in place to protect the county and the property owner. Usually counties have procedures and processes that go along with that. And if you're in doubt, consult the county attorney. That's a good resource for you. So first you have informal appeals. That's basically just an assessor review. A review of the property is requested by the taxpayer, or a review based on the assessor's own discretion. It's requested prior to the Board of Equalization convening. The assessor will make a decision, and then the taxpayer can appeal that decision or changes to the Board of Equalization and Review. So if the taxpayer doesn't agree with the change or the no change, they can go on to the Board of Equalization and Review. So formal appeals are the appeals that the Board of Equalization and Review hears. All appeals should be heard by the Board of Equalization and Review after they convene. The assessor's authority to make changes shifts to the Board of Equalization and Review once the Board of Equalization and Review convenes. Decisions should be recorded in the minutes. Written notice of that decision should be sent to the taxpayer. And the taxpayer may appeal that decision to the Property Tax Commission at the state level. Property Tax Commission hears appeals from the County Board of Equalization decisions. These must be filed within 30 days of notice of the Board of Equalization and Review decision, and it has to include a copy of that decision. It's a de novo hearing, so from the new, they'll rule on new evidence, not on prior Board of Equalization and Review hearing. parties can appeal the Property Tax Commission decision to the Court of Appeals.
Just to make sure I'm following right.
Yeah.
I mean, so, since we've convened today, when changes are made, they're recommended, and that's what comes to us in the form of staff recommendation.
Yes,
Right.
yes.
Yeah, okay. Okay. So prior to today, you could make changes, but after today, you can't.
No.
Right, sorry.
You're good. You're good. The Court of Appeals hears appeals from the Property Tax Commission decision. Those have to be filed within 30 days of the written decision of the Property Tax Commission. You can appeal the Court of Appeals decision to the Supreme Court. The Supreme Court has discretionary review of the Court of Appeals decision, and that appeal must be filed within 15 days of the mandate issued by the Court of Appeals. Powers and duties of the board. So who can be a member of the Board of Equalization and Review? It can be the Board of County Commissioners, or the county commissioners can appoint a special Board of Equalization and Review. The Board of Equalization and Review is appointed by resolution of the Board of County Commissioners. They can adopt it no later than the first Monday in March. Has to be filed with the clerk to the Board of Commissioners, and a copy needs to be submitted to the DOR. And then the Board of County Commissioners will designate a chairperson for the Board of Equalization and Review. It's a quasi-judicial board. Powers and procedures resemble a court of law. It's a fact-finding board. Decisions based on evidence and existing law. Decisions do not set precedents or create case law. Decisions should be consistent and uniform, though. These decisions can be challenged to the Property Tax Commission, and the decisions are not final until the 30 days after written notice has expired. If they wait after the 30 days, they're going to be late to the Property Tax Commission. So your decision's final after that 30-day waiting period, and they haven't filed a PTC appeal. Oath of office. You'll all take an oath of office to support the Constitution and laws of the U.S. and North Carolina. Cannot allow your actions as a member of the board to be influenced by personal or political gain. Clerk to the board. So authority to make changes shifts from the assessor to the Board of Equalization and Review after the Board of Equalization and Review convenes, but either the assessor or somebody that the assessor appoints serves as the clerk to the Board of Equalization and Review. They keep accurate minutes, provide all evidence on appeal to the Board of Equalization. Duty to review tax lists. So examine and review tax lists for the current year. List, appraise, and assess taxable property. Correct errors in name or the description of taxable property. Change the current year appraised value. Take necessary action to bring lists and records into statutory compliance. Embody actions via orders and minutes. Give written notice to the taxpayer of any increase in value. You'll hear timely appeals with respect to reduction or increase of value for taxpayers' own property, increase in value of others' property if aggrieved, or status of exemption application or for their own property or the property of others. Timely appeals are filed in writing or personal appearance to the Board of Equalization and Review. They have to be filed prior to adjournment. Filed within 15 days of the Board of Equalization notice of decision made in review of tax lists under 105-322G1. Application is timely filed if filed within 30 days of notice of discovery or 30 days after a change in value for present use value. So for those two things, if there's a discovery or if there's a change in present use value, that property owner has 30 days to appeal to the Board of Equalization and Review. Late applications. Board of Equalization and Review may approve acceptance of late application for exemption or exclusion. It applies only to the tax levied in the calendar year in which the application is filed. You cannot accept applications for prior years. You can accept for good cause, which is not statutorily described, so usually counties will have their own either definition or good cause, or they'll have policies and procedures related to that so that everything is equitable. After adjournment, everything should go to the Board of County Commissioners. You have the power to appoint committees, employ expert appraisers, examine witnesses and documents, subpoena witnesses and documents, and weigh evidence and render decisions. Power to submit reports. You can submit a report to the DOR outlining the quality of your reappraisal, problems encountered in the reappraisal process, quantity of appeals to the Board of Equalization or the PTC, success rate of those appeals, and let the DR know who's conducting the reappraisal, if it's in-house or done by an outside firm. Duty to change abstracts and records after adjournment. The Board of Equalization Review can continue to meet and decide appeals on personal property, discovery property, motor vehicles, present use value, compliance reviews usually, exemption and exclusion compliance reviews. So for hearing preparation, there's a preliminary assessor review. The assessor should review all complaints prior to the Board of Equalization review. That way they can correct factual errors early in the process and then always maintain a perception of equity and fairness. The initial meeting between the first Monday in April and the first Monday in May, that's usually when the Board of Equalization review will convene. They must adjourn by July 1st in non-reevaluation years and December 1st in reevaluation years. The adjournment deadline is interpreted as the last possible date for receiving new appeals or the last possible date for performing duties and exercising powers for the Board of Equalization and Review. You may continue to meet after adjournment to decide timely filed appeals. So if, say, you adjourn on May 1st, you can still meet to hear timely filed appeals. If somebody submitted an appeal on April 15th and you were convened, you can still meet in June, usually, to decide that appeal if you need to. It's important to be realistic in determining the time needed to hear all the requests for hearing. And then be reasonable in determining the amount of hours and frequency of meetings to complete those hearings.
Question.
Yeah.
You're stating we can. Is it we can or we should?
You should.
Okay.
So general recommendations from the Department of Revenue to convene as early as possible within the statutory time frame. During a reappraisal year, it's good to allow 3 to 8 weeks between convening and adjournment. That way you make sure that everybody has ample time to appeal. In a non-reappraisal year, 2 to 6 weeks is usually okay between convening and adjournment. Considerations when establishing the timeline: fairness, uniformity, adequate time to set the tax rate for the commissioners. That's usually a big one, especially in reappraisal years. So notices of hearings, they need to contain the dates, locations, hours, the purpose of the first meeting, convening and adjournment dates, and early or late adjournment procedures. Must be published in a newspaper of general circulation. The initial publication is 10 days prior to the first meeting, and then it must be published 3 times. And then that little table just kind of gives you an overview of the time. And I can send this out to Van if you want to distribute just as a refresher too. Format of the meetings. Maintain an appropriate level of formality for these meetings. Determine format when the Board of Equalization Review convenes and carry that format through adjournment. Adopt policies and tools so you can use sign-up sheets, hearing scripts, and evidence logs, pretty much anything you want to, as long as it's the same way throughout the process. It's open meeting, sunshine laws apply. Hearings, deliberations, and actions are public. Public access to records follow the retention schedule for the state. As always, confidential information remains confidential. So avoid conflicts of interest. So relatives, business partners, corporate interests, political gains, personal gains, fee appraisals by county employees or contracted firms or board members. If the conflict exists, you can excuse yourself from the hearing and deliberations.
Can you give an example of a political gain, like what, I'm asking that because I'm one of the local politicians.
Yeah.
So when would be a good time for me to excuse myself?
I don't think that there's anything like standard written out. I think it would. That's a difficult question.
I'll tell you how that's been approached in the past.
Uh-huh.
If you have direct financial interest in the property, you need to recuse yourself. If it's somebody, just because there's a political ally maybe, that's not a reason to recuse yourself. From a legal standpoint. The only ones we've allowed to recuse in the past were land developers that used to be on the board that had direct interest in the property or a somewhat indirect interest in the property itself. So if you have no interest in the property, there's no basis for recusal at that point.
Okay, I just want to make sure.
Yeah.
Don't want to get in trouble.
So appropriate issues for appeal, the subject property appraised substantially above market value, not equitably appraised as compared to similar properties. And then there are legal issues for appeal, so discoveries, listings, exemption, or present use value status or applications are usually part of the legal rather than value category. Inappropriate issues for appeal, the amount of the tax bill, the level of satisfaction with county services, the percentage increase in tax assessed value. That's especially concerning usually in reappraisal years. That's usually a reason that you will hear a lot, but that's not an appropriate reason for appeal. There has to be some solid facts to back those up. Economic decline of national real estate market. Post-reappraisal refinance reflects a lower market value. So if the person has gone to refinance their house and get a lower reappraisal, that's usually not a reason for appeal. So the greater weight of evidence test, they'll need to present compelling evidence based on market value, so qualified sales if they have comps. This does not consider feelings on the type of property, about the expert witness, political affiliation, financial situation, the taxpayer's primary residence, or the taxpayer's physical characteristics. So when it comes to market value evidence, you can ask the taxpayer if there's an appraisal report, if the assessment data is accurate, so if what's on the property card matches what's on the ground. Did the subject property sell prior to the reappraisal date? Did comparable properties sell prior to the reappraisal date? Income and expense data, subject property assessed comparably to similar properties. And documentation. A recent appraisal performed prior to the reappraisal date, building plans, zoning records, maps, photos, a closing settlement statement, sales data on comparable properties, income and expense statements for each of the 3 years preceding the reappraisal, or property record cards for similar properties. So, appeal decisions. After considering all the evidence, the Board of Equalization and Review adopts an order reducing, increasing, or affirming the listing or appraised value under appeal. The appellant will be notified by mail, and the notice must be sent no later than 30 days after the Board of Equalization adjourns. So what to consider, or what to include on the notice of decision. The date the notice is mailed, the description of the property under appeal, usually that's a parcel, tax ID number, the value under appeal, and then the value determined by the Board of Equalization and Review, the address and deadline for appeal to the Property Tax Commission, statement to provide copy of the Board of Equalization and Review notice with the Property Tax Commission appeal, and DOR recommended language. I know our attorney sends out different things prior to boards convening with the statements that the DOR wants on those. Some people use those forms, and then some counties create their own. It doesn't really matter which, as long as the information's on there. Appraisal standards. So we have 3 approaches to value: sales comparison, income, and cost. Sales comparison estimates property's value by reference to comparable sales. Income uses capitalization to convert anticipated benefits of ownership of the property into an estimate of present value. The cost approach determines replacement cost new, less depreciation on an improvement or asset. Market value is the most probable price a property should bring in a competitive and open market under fair sale. Market price is the actual price agreed to in a particular transaction. Market data is data derived from the market and reflects fair earning capacity of the property. The actual data reflects actual income received and may not be a true representation of the market. Highest and best use requires the property to be appraised at its most profitable use, given it's legally permissible, physically possible, economically feasible. So you use the uniform appraisal standards, appraise all properties at its true value. True value is market value. So cash price, willing and financially able buyer, willing seller. Neither party is under duress to buy or sell. The buyer and seller have knowledge of all uses of the property and its capabilities, and then it needs reasonable exposure to the market. Market value is not historical cost, construction cost, book value or depreciated asset, insurance value, value in use, liquidated or salvage value, inheritance value, or aesthetic. So schedules of values are used in appraising real property. They need sufficient detail to enable those making real property appraisals to adhere to them. They're prepared for appraising real property at its true value and present use value. So sometimes they're separate true market value and present use value schedules, and sometimes they're combined. Authorize changes to real property value in non-reappraisal years. So you're kind of limited in non-reappraisal years. You can correct clerical or mathematical errors, appraisal errors from misapplication of the schedule of values, conservation or preservation agreements that have come in, physical changes to the lands or improvements, changes in legally permitted use of the property, and then there are some other factors. This excludes any changes listed in General Statute 105-287B. here's some unauthorized changes to real property value in non-reappraisal years. So normal physical depreciation of improvements, economic changes, so inflation or deflation, betterments like painting, terracing, landscaping, forest fire protection, and impounding water for non-commercial purposes. We'll move on to
Just clarify
person.
something.
Yeah,
And I don't know if I was just missing or reading it wrong. I mean, if somebody doesn't appeal this year and they just decide to appeal next year for some reason, I mean, doesn't stop them from doing that, does it?
no, they can still appeal.
Right.
Um,
I knew that. I was just trying to,
Yeah, I
Looking at
think
the language there.
what this is trying to say is it's a little bit more strict on the changes that you can make in a non-reappraisal year. In a reappraisal year, you're trying to make sure that the schedule of values that were adopted are applied correctly, and
Right.
sometimes you will have some more changes that you can do in that reappraisal year than you can in a non-reappraisal year. They can still appeal, but you're a little bit more limited by statute on what changes you can make in those. Say they appeal next year when they really should have appealed this year, but just didn't make it a priority.
right.
They may be a little bit more limited, but if they've got a good reason to appeal, then it's probably not going to make too much of a
If they come in
difference.
with the good data and good evidence,
Yeah.
then we can make a change.
Yeah, yeah.
In a
You can still
non-
make changes, of course. It's
Right.
just, sometimes counties can be a little bit more flexible in a reappraisal year for whatever reason. There are some things like, I have seen counties who have neighborhoods where land values, something went
Out of
wrong
whack.
in their system and they had to go through and change the entire neighborhood.
Right.
And it allows you more opportunities in a reappraisal year to make those changes. But you can still pretty much do mostly the same thing in a non-reappraisal year, as long, if the appeal is valid and they've got the data to support it, you shouldn't have any problem being able to make the changes that you need to make.
Thank you.
Yeah. So for personal property, all property is taxable unless it's exempted or excluded. It includes all property that's not real. It's listed at historical cost. The cost index is provided by the DOR and depreciation schedules. Factors applied to historical cost, assessed value determined by replacement cost new less depreciation. It's accepted by courts. So personal property appraisal, replacement costs of property, sale price of similar property, the age of the property, physical condition, productivity, remaining life, effective obsolescence on the property, and economic utility or the usability of the property. Determining true value. The appraiser should consider any information reflected on the taxpayer's state or federal income tax returns, the accuracy of the taxpayer's records, the method of accounting, and the level of trade. Personal property appeals. They can appeal the value, situs, or taxability to the assessor. Must file within 30 days of notice of value. For most counties, the notice of value for personal properties is the bill. I know some other counties send personal property listings out that have those values on it, and that would be their notice of value. So whatever the case, 30 days from that notice of value for the personal property. The assessor holds conference to hear evidence. The taxpayer may sign an agreement accepting the value, or the assessor must mail a notice of decision. They may appeal the assessor decision to the Board of Equalization and review within 30 days of the notice of the assessor's final decision. So for discovery, listing, assessment, and taxation of property that's not listed during the listing period. You must send notice to the taxpayer containing the name and the address of the discovered person or entity, description of the property, tentative appraisal of the property, and a statement granting 30 days to appeal the listing and appraisal of the property. Discovery includes property listed after the listing period, listed at an understated value, listed under an exemption or exclusion for which it did not qualify, or unlisted property. Taxation, it's taxed for current year and 5 preceding years. The tax is computed at a tax rate imposed for each year. So if you had a change in tax rate from 22 to 23 on your discovery bill, you would indicate 2 different tax rates for each of those years on discovery. Penalties are 10% for the earliest year not listed, an additional 10% for each subsequent listing period that elapsed before discovery. Each year is calculated separately for mostly because of the tax rate changes that could apply. And this is just an example. It shows you this person got the discovery bill in 2023. Their penalty was 10%. It's done for the 5 preceding years, so that penalty has gone up 10% for every year they did not list. So for the line for 2018, it's 60% penalty. And you can also see on there that the tax rate from 2018 to 2020 was 50 cents. It went to 70 in 2021, back down to 60 and 50. So each line has the different tax rates on there. So with discoveries, there's a power to compromise. The Board of Equalization and Review may compromise, settle, or adjust discovery bills for any reason. Taxes must be billed and unpaid. There are no statutory guidelines for ensuring power is applied equally. Normally, counties or boards will come up with their own system for how to do this to make sure that power is applied equally. My next section here. DOR recommends the Board of Equalization limit use of this power or adopt written policies for uniform application. Decision is only reviewable by the Property Tax Commission if the taxpayer demonstrates legal discrimination or bias by the Board of Equalization and Review. So, taxpayer remedies. Collection is delayed pending appeals, so no enforced collection while under appeal to the Board of Equalization and Review or the Property Tax Commission if the tax is unpaid. The tax collector can obviously send a tax bill, they just can't do enforced collections on that tax bill. Interest on overpayments. So when an order of the Board of Equalization and Review causes overpayment, the taxpayer is entitled to get that interest back. Interest is calculated at rate and dates established by 105-360A. It accrues from the later of the date the tax is paid or the delinquency date. No tax is to be released, refunded, or compromised. So the Board of County Commissioners is prohibited from releasing, refunding, or compromising all or any portion of tax except as authorized. Unauthorized release, refund, or compromise will not affect the tax lien or the liability. Unauthorized release, refund, or compromise tax may be recovered from the members voting for the release, refund, or compromise through civil action. As far as taxpayer remedies go, they need a valid defense. Oh, sorry, I thought I heard somebody speak. So the only 3 reasons that refunds, releases, or compromises are covered in statute are if the tax is imposed through a clerical error, if it's an illegal tax, or if the tax is levied for an illegal purpose. They need to demand release or refund in writing to the Board of County Commissioners. And then if paid, they must demand a refund within 5 years of the tax due date or within 6 months of the payment date.
It may be obvious, but state an illegal tax, an example.
An illegal tax would likely be a double tax. So say you tax the same property twice, that would be the best example of an illegal tax. Or if it's a tax, say, that, I'm trying to think of a good example. So a tax on a certain neighborhood that's not done on the rest of the neighborhood, you're not allowed to do that. So that would be considered an illegal tax as well. And these taxpayer remedies are just considered by the Board of County Commissioners. I think this was put in because sometimes the Board of County Commissioners is the Board of Equalization and Review. The Board of Equalization and Review doesn't have any power to release or refund or compromise anything but discoveries. You're welcome. So who may take action on a request must be heard by the governing body. The Board of County Commissioners may only delegate authority for releases or refunds less than $100 to the finance officer, county manager, or county attorney. They cannot delegate that authority to the Board of Equalization and Review. Oh, wow. I'm already done. I thought I had a lot longer. So are there any other questions that anybody has for me?
Good refresher and informative, so it's, I don't know how many pages that is. It'd be nice to have a copy of that.
We got it on the.
Like when
on the
we're
front.
meeting.
Yeah, you can absolutely keep that and distribute it if you want to.
Like if I had a hard copy.
Yeah, we'll get you a
Yeah,
copy.
while we're meeting, if we had to refer to it.
Yeah, there's some good questions for when you have a taxpayer in front of you to know questions to ask that'll help you get to the decision you need.
Right.
It's nice to have that little, that little
Just
help.
like a quick reference guide type.
Yeah, absolutely.
Jimmy, Bob, y'all have any other questions?
Which one of these things is mine?
You might have to, I think the one on your right. Yeah.
We can give you all of them if you want.
I just wanted to ask, and I tend to do this, is there anything from your perspective you want to make sure that we know? Like, you just didn't go through it on the slide, but hey, here's something that I want to make sure that you know.
Make decisions fair and equitably, make sure that they're uniform across the board. There are some types of situations that you will see over and over again, and making sure that you're making the same types of decisions for each case regardless of the taxpayer or where the property is. I think that's the biggest thing. Just make sure that like discovery releases and things like that. If you decide to release penalties for the reason that somebody was in the hospital, then if you have that case come up again, you want to make sure that you remember that and give the other person that same amount of relief rather than saying, oh, this person was in the hospital, we'll relieve their penalties, and this person was 2 years later, and we choose not to. It's usually best to try to make it uniform. There's nothing that in statute says that, but it's usually just a good practice. Yeah.
That was it for me, Mr. Chair.
All right. Bob? Okay. Thank you very much, Lindsay.
Thank you.
Very informative. Thank you.
So the-
There's no test, is there?
No.
Okay.
No. I'm asking if I can make one.
Okay.
I got
Mr. Chairman.
Okay. All right.
So the next thing on the agenda is the rules of procedure for hearings. I sent this out to all of you via email. Hope you've had a chance to review.
Yes, sir.
This was vetted with our legal team. A couple of things she actually brought up in this presentation were points of discussion, significant discussion between Michael, myself, and the attorney. And it centers around item number 12. And I'll just read this. It's about taxpayer representation. Just as Lindsay said in the presentation, any taxpayer can appeal his or her or its property value, real or personal, or the values of property of others, owned by others. That owned by others, they have to be aggrieved by the other person's valuation, meaning the other person has a lower value. Say it's the same house sitting side by side. I think we've actually got a similar situation right now in the appeal that we're working. Almost identical houses across the street from each other, different values. One's significantly lower than the other, so we're looking into that to see. I think there's some data that on one property that we've got that we don't have on the other, and so that's why we're rectifying that. So that can come to you either separate from us or as a staff recommendation in that scenario. The question is around statute, and I think it's one of 290.
Yeah.
It talks about business representation, being a corporate officer of the business or such, or somebody authorized by the business. In those scenarios, in that statute, it specifically speaks to the PTC. It does not mention the Board of Equalization Review. So our attorney wanted me to make this board aware that under the legal code of ethics, if you allow representation by someone who's not an attorney, technically speaking, it is practice of law without a license, okay? However, practically speaking, this board has always tend to allow that. We do have the power of attorney form that we will have taxpayers, if they notify us that they're representing somebody else, we'll have them fill that out. I think the presumption is, and this may be a recommendation to Mike and, oh gosh, I can't remember his name, Tony.
Tony, yeah.
For maybe a technical change,
Okay.
to maybe include BER in that statute,
Yeah.
so that it explicitly applies to both. But I think the presumption is if it is allowed at the PTC, it can be allowed at the BER.
Is that like, I mean, you have a manufacturing operation here in Monroe, and it's owned by 3 or 4 people, and the general manager who has no ownership?
I think
is the one
it
coming
can
in here?
apply on that,
Yeah.
or maybe it's the VP. It
Right.
can also apply at the individual level.
Okay.
So I think of the worst case scenario, you've got a 90-year-old grandmother
Yeah.
who can't really get here, or maybe she's here but isn't comfortable speaking publicly. She has her son or grandson with her to represent her. We'll need that power of attorney form for that, but we're not gonna tell that individual, I don't think the board should tell that individual, your grandson can't speak on your behalf.
Right.
Does that make sense?
Well, it makes sense. What you're saying is making sense, but as I read the thing, it kept saying you don't need power of attorney.
We will have power of attorney. Yeah. We'll make, if somebody's representing somebody else, we will have them sign the power of
So-
attorney. Lindsay, you want to chime in on that?
Yeah, I'll go back. Yeah, when anybody is representing somebody else, it's generally, you need a power of attorney just to kind of cover the county. But Van's right, that statute does not explicitly include the Board of Equalization and Review. Let me go back here.
So Van, in the instance you gave about the grandson, he will not speak without a power of attorney, or you would allow him to speak?
We will have copies available, and when the appeal is filed being scheduled, we will ask the taxpayer, Belmore, Kristen, either one will ask the taxpayer, are you representing yourself or somebody speaking on your behalf? If they say they're speaking on it, then we're gonna send them the power of attorney. You need to bring this with you
Right.
when you come to the hearing.
Yeah.
If somebody happens to show up without one, we've got notaries on staff. We'll have them fill it out, have somebody notarize it, and.
Right, so they really would not be speaking without having a
Right.
signed power.
Should
of
not
attorney.
be,
Right.
correct.
Okay.
Should not be.
Okay.
Yeah, it really isn't touched on a lot in this presentation, but when we go under the other possible representatives, it does say that you can do family members or tax reps, but it is recommended that you have a power of attorney on file, because that's a protection for the county and for the property owner or the person representing their family member. It kind of keeps that practicing law without a license thing at bay.
Yeah, and I presume if we got into an instance where the client or taxpayer just did not know and you couldn't get the power of attorney signed, we could reschedule them.
Yes.
Yeah.
And there's, you're allowed to reschedule within, one reschedule within the rules and procedures.
Yeah.
I think I think we just want to make sure we're good, because in that scenario with the grandmother,
Yeah.
you don't want to make her go hire an attorney and pay $400 or $500
Right.
to represent them at this board. But with it being a quasi-judicial board, we have to make sure we're covered, okay? I think the other item that I wanted to bring attention to, which, as I mentioned in the email, we've never done before, is Section 9. It's the motor vehicle subcommittee. So you need to appoint 3 members of the board. We've never had a motor vehicle value appeal that's come to the board. Amy does a really good job of handling those, or Lamika, is she still in here? Lamika or myself, if Amy can't get it resolved with the taxpayer, one of us will handle that. But in the event one does, we're required under, because there's a BER statute that she's touching on, and we actually have special legislation that mirrors most of that statute. There's some nuances that are different, but generally speaking, it's the same. But both of those, the general statute and the special legislation, require this committee to be formed, and we've never done that. And so we need the 3 of you to come to a decision in adopting this, or if you want to wait till the next meeting, when everybody's here, or you could appoint those 2.
Well, I mean, it's got to be a committee of 3. I
It's
mean,
got to be a
could-
committee of
Could it
3.
be the 3 of us?
It could be the 3 of
Would
you.
y'all be okay with that? Yeah.
Yes, Mr. Chairman, we're here, sir.
So do I have a motion? Do we need to put it in the form of a motion?
I think after you adopt this, you can do that if you want to.
Okay.
But those are the only things I wanted to really bring to your attention. If you have any questions after reviewing the document that we sent a couple weeks ago, we can answer those. Otherwise, we're good to go with this.
Okay. Good.
So you will need a motion to approve the rules of procedure, and then Mr. Chairman, you'll sign those after the meeting.
Okay.
Mr. Chairman, I motion that we adopt our rules of procedure for Union County Board of Equalization.
Have a second.
Second.
All those in favor?
Aye.
Say aye. Aye. Opposed, like sign. Motion's carried.
Okay.
Okay.
This will be your governing document for the year, and we will carry this document forward annually. Required adoption at the first meeting. There may be tweaks here and there based on if something comes up during the prior year that wasn't really addressed in this, we'll adjust it accordingly.
Yeah, it'll be nice just to have this along with that presentation as a hard copy, I think.
I think,
Yes, we-
back to Lindsay's presentation, we're talking about the power to compromise. Typically, what the board has done on that, they've not compromised taxes, generally speaking.
Right.
They've compromised penalty. So that's kind of been the standard for the board. Again, it's your purview, it's your authority to go whichever way you want to go. But that's how that typically has been used in that power to compromise. So, any questions for staff?
No question.
I'm good.
Okay. Well, if you will make a motion forming that motor vehicle committee, and then it's up to you to adjourn.
Mr. Chairman, I have a question for staff, and that is there anything that staff want to make sure that we know, that you feel we need to know?
I think we're good.
So that motion to form the motor vehicle committee probably needs to come from someone besides me, I
Yes.
presume. Probably stating the names on, yeah.
Motion to establish a subcommittee on motor vehicle. How do I phrase that?
And those members to be,
MVR subcommittee.
I would say your motion probably, yes, your motion needs to be in accordance with general statute and the board rule, Union County Board Rules of Procedure. You need a motion per section 9 to establish the motor vehicle evaluation subcommittee consisting of these members.
Do you want me to just iterate what you just said?
Yeah, that's fine, that's fine,
Repeat what you just said?
that's fine.
I'm not sure I can.
Did you?
Or you can say it however you
yeah.
feel like saying it.
Okay, would like to submit that we create a committee, MVR subcommittee That would include myself, the three board members here today.
Which to clarify would be Jimmy Benchin and Dutch Hardison.
Jimmy, that's.
Right.
Bob O'Keefe.
Yeah. And so I have a motion, I have a second.
Second.
All those in favor say aye. Aye. Opposed, like sign, motion's carried. And now we have a motor vehicle subcommittee.
And we'll, if we have one of those come up, we will schedule that on a normal meeting day. It won't be a special meeting.
Oh, okay, good,
Yeah.
good.
We don't want to interrupt your golf game.
Thank you. Do we have to elect a vice chair at this meeting, or do we?
You actually do.
Yeah,
You need a vice chair as well. 'Cause in the absence of Mr. Hardison, somebody will have to sit in that role.
yeah. Because there's going to be a few days, I know I'm going to be gone in June.
Okay.
Yeah. And can I make a motion?
Sure.
Can I? I would motion that we select Mark Ashcraft, vice chair. Would he,
Second.
has he,
He has not expressed to me interest or non-interest in serving in
Right.
that role.
okay,
I haven't talked to him about it at all.
yeah. Okay. And so that'll be in the form of a motion.
So move, Mr.
Yeah.
Chairman.
Got a motion, second. All those in favor say aye. Aye. Opposed, like sign. Yeah. Okay.
That's it.
Yeah.
Motion to adjourn?
And motion to adjourn.
So move, Mr. Chairman.
Okay. Motion, second.
Second.
All those in favor say aye.
Aye.
Opposed, like sign. Motion, and meeting's adjourned. So,
Thank you, gentlemen.
yeah, okay. And I thought we could,
Thank you.
That's right. Teach you how to be here, right? Thank you all.
Thank you.